Major breaking news. The United States Supreme Court has just acted this morning by granting cert in the Wolford case out of Hawaii, dealing with the question of whether or not the state, the government, can prohibit you from carrying your handgun on private property that is open to the public, i.e. stores, gas stations, movie theaters, and the like. This is a big deal, folks, because this so-called vampire rule is a new gimmick that the anti-gunners have invented, and it looks like the Supreme Court is about to slap it down. Or will they? We got to break it down in geeky detail in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so I would say we had a slight surprise this morning, not a massive surprise, but a slight surprise this morning that the U.S. Supreme Court has come out and just granted cert in the Jason Wolford versus Hawaii case dealing with the so-called no carry default rule, or the default no carry rule, whatever you want to call it, sometimes referred to as the vampire rule. And this is the law that sort of the anti-gunner states have passed. It basically says that even if you have a concealed carry permit, you are not allowed to walk into or enter private property where that private property is open to the public. So if it's a privately owned gas station, if it's a privately owned movie theater, if it's a privately owned grocery store, any of these things under the so-called vampire rule or the no carry default rule, you are not allowed to go onto that property unless you first get express permission from the owner or manager of that gas station, of that theater, of that grocery store, of that private property thing open to the public. Now, as a practical matter, owners and managers cannot even be found half the time, and almost none of them are going to put a guns allowed in the store sign because they're not even going to think about it or care enough about it. Which means that the default provision is that if you carry your gun consistent with the Second Amendment, you can't walk onto these pieces of property unless you either speak to the owner on the phone and get permission, or he puts a sign in the door that says guns allowed, or any of these things. So as a practical matter, it basically makes an entire state verboten from the carrying of guns for self-defense on things that are open to the public. Now, what's interesting is the Ninth Circuit Court of Appeals in the Wolford case sort of split the baby here in a weird way. We've covered this before. In the Wolford case and related cases, the Ninth Circuit Court of Appeals found that the California so-called vampire rule, or no carry default rule, was unconstitutional under the Second Amendment. So did other courts like the Second Circuit Court of Appeals in Antonyuk. However, the same Ninth Circuit that said that the California no carry default rule was unconstitutional, the same Ninth Circuit came out and said that that rule as adopted in Hawaii was indeed constitutional under the Second Amendment. So this gave rise to a circuit split, meaning some of the courts of appeals in the United States said that the no carry default rule was constitutional under the Second Amendment. That would be the Ninth Circuit in Hawaii. And other courts said it was unconstitutional, thereby creating a split of authority among the lower federal courts. So Alan Beck, the excellent lawyer out of Kauai in California, sought cert in the Wolford case to the Supreme Court. And he got assistance because the United States Department of Justice, and for those of you out there that like to bash on Pam Bondi and Donald Trump, take note of this. Alan Beck's cert petition to the U.S. Supreme Court, which was well crafted, got support in the form of an amicus brief by the Donald Trump Department of Justice, where they submitted on behalf of John Sauer, the Solicitor General, and Harmeet Dillon, the head of the Civil Rights Division, and others, that the Supreme Court should grant cert in Wolford and resolve once and for all in favor of the Second Amendment this question of whether or not a state or a government can pass a law. This is you cannot carry as a matter of default. Just the default principle is you cannot carry your gun into private property, even if it's open for business. Stores and grocery stores and gas stations and the like. And the Supreme Court just granted cert in this case. This is the question they just granted cert on. The question presented is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. Now, there were some other questions presented that were not granted cert on, but I don't think that matters because I think the other questions presented are really about the Bruin methodology of text first and history second and what are appropriate historical analogs. The reason why I don't think that's as big of a deal is because I actually think that the questions presented, the other questions presented about the Bruin methodology are basically going to get answered in the context of the Supreme Court deciding this Wolford case. So I think this is overall very good news that the Supreme Court has granted cert. But now I'm going to get to, in a few minutes, some curveballs and some potential problems with it. Because again, you turn into the Four Boxes Diner to kind of get the good and the bad and the ugly as I see it. Okay, so let me start with the very good news. The very good news is that the Supreme Court granted cert in this case. And I think because, and I've said this before, because this procedural posture was on an interlocutory basis. This was a cert petition arising from a preliminary injunction fight. Now, as I've explained to you before, as a general matter, and most of the time, it is not a good idea or it's not a successful approach to seek cert to the U.S. Supreme Court where the case is on an interlocutory appeal because the Supreme Court generally likes to hear a case on a final judgment so that all the facts have been uncovered, all the laws been analyzed, and so on. However, the Department of Justice and the lawyers for Mr. Wolford here made some very strong points about why, even though the Wolford case is on an interlocutory appeal, meaning it's in the middle of a case, the case has not been fully adjudicated, there's no final judgment yet, it's still being litigated on the preliminary injunction basis. They argue that, look, there's no additional facts, there's no additional law that needs to be uncovered. There's no benefit to the process of what's known as percolation in the lower courts to come up with the complete panoply of ideas and thoughts and all the different theories that you need for the Supreme Court likes to consider. And the argument here is that this particular issue has been litigated already for many years, including in other courts of appeals that have issued very long opinions on the question of the so-called vampire rule or the no carry default rule, included in the Ninth Circuit, where you have very powerful opinions and a very powerful dissent here by none other than potential future Supreme Court Justice Lawrence Van Dyke, who basically goes into extreme detail, as you know he would, pointing out why the Hawaii law and the California law were totally unconstitutional under the Second Amendment, for all the reasons articulated, including the methodology, the historical analogs that the government tried to justify the modern-day gun control law with, and so on and so on. So the question becomes, big picture, is why did the Supreme Court grant cert on a Second Amendment case on an interlocutory posture where they almost never, ever do that? And I think this is actually good news for the Second Amendment. Good news. And why do I say that? Again, the default principle, if you will, is the Supreme Court will not take a case on interlocutory basis. They don't like it. However, in my view, and I think the Supreme Court's going to agree here, this law by Hawaii is so insanely egregious and so obviously violative of the Second Amendment that this is a slam dunk easy win for 2A, and it's an easy opinion for the U.S. Supreme Court to write up. This is a no-go zone. And you also have, so I think that's very positive that they looked at this case and they said, this is such a slam dunk and so egregious that frankly, we don't need more time to figure this one out. This is not going to be a hard question. We're going to rule for the Second Amendment big time, and it will not be a lot of work. That is sort of what I think the court might be thinking. The other thing is, and this is now we're going to talk about Trump and Bondi for a second. I know a lot of people out there complain about them in the Second Amendment, but hopefully their record is proving I'm right and those critics are really wrong, that they are indeed doing great work for the Second Amendment. Because for the first time in American history that I'm aware of, the U.S. Department of Justice urged the Supreme Court to hear a Second Amendment case. Okay? They've been involved with other Second Amendment cases, but this is the first time they've actually submitted an amicus brief urging the Supreme Court to grant cert in an amicus in a Second Amendment case. And that is this appeal, this amicus brief by the Trump administration urging the court to take on this cert petition and to grant it. So I think there's two positive signs here. One is that the Supreme Court thinks this is such a slam dunk case in favor of the Second Amendment, they're willing to take the case on an interlocutory basis, which they almost never do. The other positive indication here is that it shows that they're paying close attention to the United States Department of Justice and the Trump administration's positions on the Second Amendment. And as you know, they're overall excellent when it comes to the Second Amendment, with a couple narrow exceptions we can talk about in a future video. But for the purposes of this, they're clearly on the correct side, saying that this particular no-fault carry default provision is unconstitutional under the Second Amendment and needs to be addressed and struck down. Now, before I give you some language from the briefs that I think will be helpful to fully understand the case, I do want to give you a word of warning, because that's why you tune into this channel. Here is what you're about to see, I suspect. The state of Hawaii enacted this law. The state of Hawaii could now go out and eliminate the law on its own initiative. They could change the law and delete this from their statutory body of laws. If Hawaii were to, let's say in the next month, eliminate the law, guess what? That would arguably moot out this case. And if the case is mooted, as a general matter, the U.S. Supreme Court will drop the case and not decide it. As you may recall, in 2020, there was another NYSERPA case. This is not NYSERPA versus Bruin I'm about to talk about. This is NYSERPA versus the city of New York, dealing with carrying guns to and from a gun range outside of the city of New York, and whether or not the rules that New York City had in place for concealed carry holders when it came to carrying your guns to a place outside New York for practice, whether or not that was constitutional under the Second Amendment. The Supreme Court granted cert in that case, which was going to require them to discuss whether or not there is a right to carry your gun from your home to other places in the country. But what happened after cert was granted in that case of NYSERPA versus City of New York? What happened? The state of New York and the city of New York came together. All the anti-gunners came together in the state of New York and passed a law that eliminated, vacated, if you will, that particular law that was at issue and being challenged in the U.S. Supreme Court, thereby mooting out the NYSERPA versus City of New York case, preventing the Supreme Court from issuing a ruling that we would have won on in favor of the Second Amendment. So here in the Wolford case, the main question as I see it is, will the state of Hawaii now take steps to repeal this no carry default rule, the so-called vampire rule? Will they take steps to eliminate the law and thereby moot out this particular case before the Supreme Court, the Wolford case? Because as I've explained to you before in other contexts, under Article 3 of the United States Constitution, federal courts, including the Supreme Court, only have jurisdiction to hear what are known as cases and controversies. And one thing that's a case or controversy is it's an active ongoing fight, an active ongoing legal dispute. So if Hawaii eliminates this law by virtue of statutory action, the legislature eliminates this law in Hawaii, there'll be nothing to fight over anymore because the law will be gone, right? And as a consequence, that will moot out the Supreme Court case, which will mean that the U.S. Supreme Court will not be able to act on it and rule on it and issue an opinion, presumably in favor of the Second Amendment. So that, in one sense, will be very good news for Hawaii gun owners because the law will have been changed in their favor, but it will be bad picture-wise from the Second Amendment point of view because another opportunity to win on the Second Amendment and have good precedent and another brick in the wall, if you will have been lost because Hawaii will have mooted out this Wolford case. Now, again, the reason why I think we do not want this case to be mooted is twofold. One is I think there's a very good chance the Supreme Court's going to rule in our favor, and it'll be another victory for the Second Amendment at the Supreme Court, which is like multi-generational. In other words, a win before the Supreme Court has an effect that goes decades into the future, usually. Even if we have a President Gavin Newsom in a few years, I'm not predicting that, but if we did, the Supreme Court precedent set in Wolford presumably would be very good and would last beyond even the Newsom term. So that's very good. Beyond that, the discussion of what are appropriate methodological and historical analog laws to be considered will definitely be discussed in this case, and they could come out very favorable, and they likely will, because the two main arguments, as I see it, that the anti-gunners use to justify this no carry default rule out of Hawaii, saying they can't carry guns in private property open to the public without permission of the owner ahead of time. The two main laws is they use some laws from the late 19th century involving the black codes. And as you know, that's too late in time. In fact, actually, the brief in favor of petition here, the petition brief actually cites favorably to my article in the Harvard Journal of Law and Public Policy on this exact point. And I'm clearly right, and the Supreme Court will ultimately agree with me on this point, which is that the relevant time period is the founding era and not post-Civil War history, for the reasons I've articulated in that article. And I think the Supreme Court already agrees with me, but they haven't really expressly said it for reasons we can talk about in a separate video. Beyond that, I think the other issue, or the other historical analog laws that the anti-gunners like to use to justify this so-called vampire rule, is these laws that are really anti-poaching laws to say you can't bring guns onto farmers' property and things like this. But if you look at those historical analog laws, a lot of those, frankly, are dealing with we don't want people hunting on property and taking game and things like that on other people's property. It has nothing to do with simply peaceably carrying a handgun or peaceably carrying a gun on the property for self-defense. It's really about you can't go hunting on my property if I don't give you consent because it affects my property rights. So I don't think that's going to apply to the peaceable carrying of handguns in your pocket on private property open to the public without having to get permission from the owners first and foremost. Okay, just before we wrap up, I just want to read one little clause here from the Department of Justice amicus brief explaining why they want the Supreme Court to hear this case. Check it out. The United States has a substantial interest in the preservation of the right to keep and bear arms and in the proper interpretation of the Second Amendment. From the earliest days of the Republic, individuals have been free to carry firearms on private property unless the property owner directs otherwise. Yet after Bruin, 5 states, including Hawaii, inverted the long-standing presumption and enacted a novel default rule under which individuals may carry firearms on private property only if the owner provides express authorization. All right, folks, so there you have it. Hope you enjoyed today's episode. Make sure you follow me over there on X at 4 Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.